important is the ultimate recommendation of the guardian ad litem in family court?
Very important. The court doesn't automatically have to adopt their recommendation, but they...
Hello, and thank you for being with us again today. I have with me attorney Bailey Holt. Bailey is a senior associate with us at Sterling Law Offices. Thank you for joining us today, Bailey.
I'm happy to be back again.
Yes, and we are going to continue our conversation. I know in a prior episode we had talked kind of a high-level discussion on social workers and guardian ad litems, the experts involved in cases involving children. And I want to dig in a little deeper on that today, on sort of strategies and the do's and don'ts when a guardian ad litem is involved in your case. And let's dig into that, like how to prepare yourself and what happens if you think that maybe they're not doing a good job. Because I think a lot of our listeners are quite concerned about guardian ad litem investigations and how they can present themselves best. So what can a client expect when a guardian ad litem is assigned to their case? What are the initial steps in that investigation?
Yeah. So when a guardian ad litem's first appointed, the guardian ad litem typically reaches out to the attorneys that are on the case first. I typically would probably have a call with the guardian ad litem first, kind of give them the background on the case, let them know where things are at, the procedural history, and kind of our position on the case. Typically during that initial outreach with the guardian ad litem that I have, they would ask if they have permission to communicate with my client. They do have to ask for this permission to discuss directly with parents. I almost always would agree to letting the guardian ad litem talk with parents without me having to be involved unless I have concerns about my client, maybe not being completely appropriate with the guardian ad litem. I think it's helpful for clients to be able to have that open communication with the guardian ad litem. We don't want to come off as being evasive or unwilling to participate. So most of the time, I do think it's helpful for the guardian ad litem to have that communication directly with my client. So typically the guardian ad litem would first want to meet with the client, both my client and then the other party as well. And after that, then they would want to meet with the child, unless they're like an infant and aren't really able to express any interest at all, or not only, even when kids can't talk yet, it's sometimes still helpful for guardian ad litems to go observe how they interact maybe with one parent compared to another. Still could be helpful as part of their investigation. Finally, a guardian ad litem would talk to other people that are close with the kids. Maybe it's close family or friends, who's providing childcare, doctors, etc. It just kind of depends on the kid and their specific situation. I always like to have like a brief phone call with my client before they have any meeting with a guardian ad litem, just to kind of prep them for what the guardian ad litem is going to be talking about, what to expect, what questions to expect, what's important to share, and maybe what wouldn't be important to share, to make sure that the guardian ad litem is getting the best information for the case.
Yeah, okay, that makes a lot of sense. It's an important meeting, so you'd want them to be prepared. Can you give me some, examples of specific advice you would give to your clients heading into a meeting with a guardian ad litem?
Yeah. The first thing I always say is speak positively about your relationship with the kids, and as much as you can about the other parent too, even though it might be hard, as positively as you can talk about your kids and your relationship with them is really important. I think sometimes bad mouthing the other parent too much can come off as a red flag and be seen as a problem. That's not to say don't be honest and don't share concerns that you have. I just think it can be done in a way that's showing that these are real, genuine concerns you have, and it's not just hatred you might have for the other parent. I think it's important to talk about your relationship with the child, like the history. So talking about the role you played as a parent during the child growing up. For example, what was the bedtime routine? Who did homework? Who was responsible for doctors and dentist appointments? Who went to the kids' activities? or was buying them things they needed, disciplining the kids. All of that is helpful for the guardian ad litem to understand when completing their investigation. It also would be helpful for guardian ad litems to know any specific needs your child might have. For example, if they have any sort of special like IEP they have at school, if there's any sort of anxiety they have, attachment issues they might have, behavioral issues. Filling the guardian ad litem in on all of that is going to be really important too. But most importantly, just be honest, be responsive. You want the guardian ad litem to have a good impression of you as a parent.
Yeah, that's great advice. And so you had said, don't focus your time bashing the other parent.
Yeah.
Focus your time on how are you a good parent and how is your relationship healthy with your child. Any other, you know, recommendations of things they shouldn't do heading into that meeting?
You shouldn't coach your kids. You shouldn't tell your kids what to say. It's obvious if kids are going in there and repeating something someone told them versus being genuine most of the time. Guardian ad litem can catch on to that. It always backfires and it looks like you're trying to use the kid as a pawn. Same with recordings. People often are trying to record their kids, getting them to say things on camera. 99% of the time, this is not helpful. And guardian ad litems don't like it, social workers don't like it, the court doesn't like it. So I always say try to avoid doing that at all costs, especially if your kids are aware of the recording. That's even worse.
Yeah, great advice. Okay, and so ultimately, then the guardian ad litem meets with the parents, meets with the children, maybe meets with some of these third parties who interact with the children. They put into some sort of written report what they're finding. I mean, tell us a little bit about how the GAL reports back to the court and what might go into that report.
Sometimes it's like a guardian ad litem will draft an actual formal written report and submit it to the court. For example, I think a lot of guardian ad litems in Waukesha County do that. Some will just have an email recommendation. It's very informal. They'll kind of fill both attorneys in on what their recommendation is and give it in that format. But it'll get at your court hearing. There'll be a hearing typically to review the guardian ad litem recommendation, where the guardian ad litem typically will give like an oral outline of their position on the case and what went into their findings. For example, they'll talk about who they met with, if there was any allegations of safety, mental health, substance abuse issues, and if those are being addressed or how those are being addressed. They would talk about the current placement arrangement on how that's working or not working. They would talk about their meeting of the kids, what they observed the kids with each parent. If the kids noted a preference with one parent over another parent, that might be brought into their recommendation. That's not to say, though, I don't want to confuse that kids automatically get to decide where they want to live, because that's certainly not the case. It's something that a guardian ad litem can consider, but it's not the end all be all. Just because a kid wants something doesn't necessarily mean that's what's going to happen. The role of the guardian ad litem is to advocate for what's in their best interests, and what the kid wants might not always be in their best interest, which is why they have this person to look out for their best interests.
Yeah, that's really a helpful and important distinction, isn't it? Because as you just said, kids don't always know what's best for them. If we let kids decide what to eat for dinner, they'd have ice cream and brownies, and it's probably not always a different analogy when it comes to who they want to live with, because sometimes they may choose a path of least resistance. They want somebody who never disciplines, who doesn't have bedtimes, who doesn't have a structured routine, or doesn't make them do their homework. Well, that's not really in the kid's best interest, is to live with that parent. So that's a great thing to point out in this whole discussion. So how important is the ultimate recommendation of the guardian ad litem in family court?
It's very important. Assuming that the guardian ad litem conducted a thorough investigation, I mean, the judge or commissioner gives a lot of weight to their recommendation. The court doesn't automatically have to adopt their recommendation, but they place a lot of weight on that recommendation. I mean, the whole point of the process is for the judge to have a neutral, objective person looking into the case and advocating for what's in the best interest of the child. So if the guardian ad litem has checked all these boxes and done all of that, a lot of the times they are going to look towards their recommendation when making decisions for the kids.
And what happens if you hate that recommendation? I mean, can you challenge a guardian ad litem's recommendation?
Sure. Yeah. Either party is able to challenge the recommendation of a guardian ad litem. It's not just because that's what the guardian ad litem says they're recommending, doesn't necessarily mean it becomes an order of the court. Maybe at that juncture, if one party doesn't agree with the guardian ad litem, then you're getting the social worker involved. You're having another person step in and do another investigation. But no, neither party's required to agree with the recommendation of the guardian ad litem. And if either party wants to have a trial in front of a judge and challenge the recommendation of a guardian ad litem, you're able to do that. If you want to do that, you would have to present your own evidence showing that the guardian ad litem's position is wrong, that they might have missed things in their investigation, they didn't look at certain evidence, they didn't talk to certain people. Those are the types of things you would want to have ready if you're going to be objecting or not agreeing with the guardian ad litem's recommendation.
Got it. And going one step further than that, I mean, could you ever actually have a GAL removed from a case or substituted with a different guardian ad litem if you were unhappy with them?
Theoretically, yes, but you don't see that very often or happen really at all. It's pretty standard that a guardian ad litem would stay on the case throughout the entirety of the case. It's kind of expected that one parent might not fully agree with the recommendation of the guardian ad litem, and just because you might not like their recommendation doesn't necessarily mean that's enough of a reason to have them removed from the case. You would need to show that there's been some sort of bias, that there's like a conflict of interest, that they violated some ethical violation. In order to have them removed from the case, it would require you to file a motion with the court and have a hearing on the issue. But generally speaking, courts trust the guardian ad litems. So unless you have really compelling evidence to have them removed from a case, it's likely not going to happen. So I would recommend just trying to work with the guardian ad litem or evaluator, not against them, because a lot of times that only is going to not help your case. It's going to make things worse rather than better for you.
Yeah, that's great advice. I mean, because I would say I could count on one hand the number of guardian ad litems that have been removed on cases, but it's like I could count on 0 fingers in my 17-year career how many times I've seen it. So yeah, I think that's spot on advice is don't bank on getting a guardian ad litem substituted. You're much better to work with them and try to get them to agree that you are a fit and appropriate parent, and that's going to be a much more likely outcome than getting them substituted on a case. So great advice there. Well, thank you. This was very helpful. I mean, it sounds like these guardian ad litems have a lot of influence. They are people that the courts rely on, and rarely are they going to be substituted off of a case. But they're not infallible, and it sounds like with perhaps the right documentation and strategy, you can either work with them for an outcome that you'll be satisfied with, or you can challenge them in court if you're unhappy with the direction they've taken on your case. So excellent advice, Bailey. We really appreciate you being with here. Always helpful. Thank you so much.
Thank you.
You just learned how to handle a guardian ad litem. Now, what happens when a social worker gets involved as well? Most parents think they're the same thing, and that confusion can destroy your case before you even realize what's happening. Here is what you need to know about navigating both in our next video.